Welcome to Primary Sources. I'm Jason Beets. This week, I will read and discuss the Women's Health Protection Act, a proposed federal bill that protects the right of a pregnant person to obtain an abortion. Pro-choice lawmakers who support the bill say that it would override state laws, like the law that recently took effect in Texas, which limit the right of a pregnant woman to obtain an abortion. To learn more about the Texas law, which effectively bans abortions after 6 weeks of pregnancy, you can listen to the first episode of Primary Sources, where I read the U.S. Supreme Court decision that allowed the Texas law to take effect. The Women's Health Protection Act begins with a list of findings, which essentially summarize the pro-choice view on the state of abortion rights in the U.S. After this preamble, the bill proceeds to its operative clauses that would actually amend federal law. Now let's take a look at the text of the Women's Health Protection Act. The Women's Health Protection Act of 2021, as introduced. A bill to protect a person's ability to determine whether to continue or end a pregnancy and to protect the health care provider's ability to provide abortion services. Section 1, short title. This act may be cited as the Women's Health Protection Act of 2021. Section 2, findings and purpose. A. Findings. Congress finds the following. Abortion services are essential health care, and access to those services is central to people's ability to participate equally in the economic and social life of the United States. Abortion access allows people who are pregnant to make their own decisions about their pregnancies, their families, and their lives. Since 1973, the Supreme Court repeatedly has recognized the constitutional right to terminate a pregnancy before fetal viability, and to terminate a pregnancy after fetal viability where it is necessary, in the good faith medical judgment of the treating healthcare professional, for the preservation of the life or health of the person who is pregnant. Nonetheless, access to abortion services has been obstructed across the United States in various ways, including blockades of healthcare facilities and associated violence, prohibitions of and restrictions on insurance coverage, parental involvement laws, notification and consent, restrictions that shame and stigmatize people seeking abortion services, and medically unnecessary regulations that neither confer any health benefit nor further the safety of abortion services, but which harm people by delaying, complicating access to, and reducing the availability of abortion services. Reproductive justice requires every individual to have the right to make their own decisions about having children, regardless of the circumstances and without interference and discrimination. Reproductive justice is a human right that can and will be achieved when all people, regardless of actual or perceived race, color, national origin, immigration status, sex, including gender identity, sex stereotyping, or sexual orientation, age or disability status, have the economic, social, and political power and resources to define and make decisions about their bodies, health, sexuality, families, and communities in all areas of their lives, with dignity and self-determination. Reproductive justice seeks to address restrictions on reproductive health, including abortion, that perpetrate systems of oppression, lack of bodily autonomy, white supremacy, and anti-black racism. This violent legacy has manifested in policies including enslavement, rape, and experimentation on black women, forced sterilizations, medical experimentation on low-income women's reproductive systems, and the forcible removal of indigenous children. Access to equitable reproductive health care, including abortion services, has always been deficient in the United States for Black, Indigenous, and other people of color and their families. The legacy of restrictions on reproductive health, rights, and justice is not a dated vestige of a dark history. Presently, the harms of abortion-specific restrictions fall especially heavily on people with low incomes, Black, Indigenous, and other people of color, immigrants, young people, people with disabilities, and those living in rural and other medically underserved areas. Abortion-specific restrictions are even more compounded by the ongoing criminalization of people who are pregnant, including those who are incarcerated, living with HIV, or with substance use disorders. These communities already experience health disparities due to social, political, and environmental inequities, and restrictions on abortion services exacerbate these harms. Removing medically unjustified restrictions on abortion services would constitute one important step on the path towards realizing reproductive justice by ensuring that the full range of reproductive health care is available to all who need it. Abortion-specific restrictions are a tool of gender oppression, as they target healthcare services that are used primarily by women. These paternalistic restrictions rely on and reinforce harmful stereotypes about gender roles, women's decision-making, and women's need for protection instead of support, undermining their ability to control their own lives and well-being. These restrictions harm the basic autonomy, dignity, and equality of women, and their ability to participate in the social and economic life of the nation. The terms woman and women are used in this bill to reflect the identity of the majority of people targeted and affected by restrictions on abortion services, and to address squarely the targeted restrictions on abortion, which are rooted in misogyny. However, access to abortion services is critical to the health of every person capable of becoming pregnant. This act is intended to protect all people with the capacity for pregnancy: cisgender women, transgender men, non-binary individuals, those who identify with a different gender, and others, who are unjustly harmed by restrictions on abortion services. Since 2011, states and local governments have passed nearly 500 restrictions singling out healthcare providers who offer abortion services, interfering with their ability to provide those services and the patient's ability to obtain those services. Many state and local governments have imposed restrictions on the provision of abortion services that are neither evidence-based nor generally applicable to the medical profession or to other medically comparable outpatient gynecological procedures, such as endometrial ablations, dilation and curettage for reasons other than abortion, hysteroscopies, loop electrosurgical excision procedures, or other analogous non-gynecological procedures performed in similar outpatient settings, including vasectomy, sigmoidoscopy, and colonoscopy. Abortion is essential health care and one of the safest medical procedures in the United States. An independent comprehensive review of the state of the science on the safety and quality of abortion services, published by the National Academies of Sciences, Engineering, and Medicine in 2018, found that abortion in the United States is safe and effective, and that the biggest threats to the quality of abortion services in the United States are state regulations that create barriers to care. These abortion-specific restrictions conflict with medical standards and are not supported by the recommendations and guidelines issued by leading reproductive health care professional organizations, including the American College of Obstetricians and Gynecologists, the Society of Family Planning, the National Abortion Federation, the World Health Organization, and others. Many abortion-specific restrictions do not confer any health or safety benefits. Instead, these restrictions have the purpose and effect of unduly burdening people's personal and private medical decisions to end their pregnancies by making access to abortion services more difficult, invasive, and costly, often forcing people to travel significant distances and make multiple unnecessary visits to the provider, and in some cases, foreclosing the option altogether. For example, a 2018 report from the University of California, San Francisco's Advancing New Standards in Reproductive Health Research Group found that in 27 cities across the United States, people have had to travel more than 100 miles in any direction to reach an abortion provider. An overwhelming majority of abortions in the United States are provided in clinics, not hospitals, but the large majority of counties throughout the United States have no clinics that provide abortion. These restrictions additionally harm people's health by reducing access not only to abortion services, but also to other essential health care services offered by many of the providers targeted by the restrictions, including screenings and preventative services, including contraceptive services, testing and treatment for sexually transmitted infections, LGBTQ health services, and referrals for primary care, intimate partner violence prevention, prenatal care, and adoption services. The cumulative effect of these numerous restrictions has been to severely limit the ability of abortion services in some areas, creating a patchwork system where access to abortion services is more available in some states than in others. A 2019 report from the Government Accountability Office examining state Medicaid compliance with abortion-covered requirements analyzed 7 key challenges identified both by healthcare providers and research literature, and their effect on abortion access, and found that access to abortion services varied across the states and even within a state. International human rights law recognizes that access to abortion is intrinsically linked to the rights to life, health, equality and non-discrimination, privacy, and freedom from ill treatment. United Nations human rights treaty monitoring bodies have found that legal abortion services, like other reproductive health care services, must be available, accessible, affordable, acceptable, and of good quality. UN human rights treaty bodies have likewise condemned medically unnecessary barriers to abortion services, including mandatory waiting periods, biased counseling requirements, and third-party authorization requirements. Core human rights treaties ratified by the United States protect access to abortion. For example, in 2018, the UN Human Rights Committee, which oversees the implementation of the International Covenant on Civil and Political Rights, also known as the ICCPR, made clear that the right to life enshrined in Article 6 of the ICCPR at a minimum requires governments to provide safe, legal, and effective access to abortion where a person's life and health is at risk, or when carrying a pregnancy to term would cause substantial pain or suffering. The committee stated that governments must not impose restrictions on abortion which subject women and girls to physical or mental pain or suffering, discriminate against them, arbitrarily interfere with their privacy, or place them at risk of undertaking unsafe abortions. Furthermore, the committee stated that governments should remove existing barriers that deny effective access to safe and legal abortion, refrain from introducing new barriers to abortion, and prevent the stigmatization of those seeking abortion. UN independent human rights experts have expressed particular concern about barriers to abortion services in the United States. For example, at the conclusion of his 2017 visit to the United States, the UN Special Rapporteur on Extreme Poverty and Human Rights noted concern that low-income women face legal and practical obstacles to exercising their constitutional right to access abortion services, trapping many women in cycles of poverty. Similarly, in May 2020, the UN Working Group on Discrimination Against Women and Girls, along with other human rights experts, expressed concern that some states had manipulated the COVID-19 crisis to restrict access to abortion, which the experts recognized as the latest example illustrating a pattern of restrictions and retrogressions in access to legal abortion care across the country, and reminded U.S. authorities that abortion care constitutes essential health care that must remain available during and after the pandemic. They noted that barriers to abortion access exacerbate systemic inequalities and cause particular harm to marginalized communities, including low-income people, people of color, immigrants, people with disabilities, and LGBTQ people. Abortion-specific restrictions affect the cost and availability of abortion services, and the settings in which abortion services are delivered. People travel across state lines and otherwise engage in interstate commerce to access this essential care, and more would be forced to do so absent this act. Likewise, healthcare providers travel across state lines and otherwise engage in interstate commerce in order to provide abortion services to patients, and more would be forced to do so absent this act. Healthcare providers engage in a form of economic and commercial activity when they provide abortion services, and there is an interstate market for abortion services. Abortion restrictions substantially affect interstate commerce in numerous ways. For example, to provide abortion services, healthcare providers engage in interstate commerce to purchase medicine, medical equipment, and other necessary goods and services. To provide and assist others in providing abortion services, healthcare providers engage in interstate commerce to obtain and provide training. To provide abortion services, healthcare providers employ and obtain commercial services from doctors, nurses, and other personnel who engage in interstate commerce and travel across state lines. It is difficult and time and resource consuming for clinics to challenge state laws that burden or impede abortion services. Litigation that blocks one abortion restriction may not prevent a state from adopting other similarly burdensome abortion restrictions or using different methods to burden or impede abortion services. There is a history and pattern of states passing successive and different laws that unduly burden abortion services. When a healthcare provider ceases providing abortion services as a result of burdensome and medically unnecessary regulations, it is often difficult or impossible for that healthcare provider to recommence providing those abortion services, and difficult or impossible for other healthcare providers to provide abortion services that restore or replace the ceased abortion services. Healthcare providers are subject to license laws in various jurisdictions, which are not affected by this Act except as provided in this Act. The next part of the bill is very important. It outlines Congress's constitutional authority to make changes to federal law that protect abortion rights. Congress has the authority to enact this act to protect abortion services pursuant to its powers under the Commerce Clause of Section 8 of Article 1 of the Constitution of the United States. Okay, so let's take a look at the Commerce Clause in the Constitution. So Article 1, Section 8 of the U.S. Constitution includes a provision which states, Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes. Article 1, Section 8 also explains, Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof. Heading back to the Women's Health Protection Act, the bill also states that Congress has the authority to enact this act to protect abortion services pursuant to its powers under Section 5 of the 14th Amendment of the Constitution of the United States to enforce the provisions of Section 1 of the 14th Amendment. So let's take a look at the 14th Amendment as well. The 14th Amendment was one of the amendments passed during Reconstruction following the Civil War, primarily with the goal of providing rights to the newly freed black slaves in the American South. The 14th Amendment, Section 1, reads as follows. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Section 5 of the 14th Amendment states the Congress shall have the power to enforce, by appropriate legislation, the provisions of this article. The Women's Health Protection Act, were it to become law, would immediately be subject to challenge by pro-life supporters in the courts. So within the bill, it contains reference to the constitutional provisions which supporters of the bill say give Congress the power to enact the law. So specifically, Section 5 of the 14th Amendment says Congress has the power to enforce the provisions of the rest of the amendment. And Section 1 of the 14th Amendment, when it comes to constitutional interpretation, is a pretty big deal. It contains the Due Process Clause and the Equal Protection Clause, both of which, when it comes to constitutional rights, are pretty important in a wide variety of circumstances. In this bill, those rights are being invoked to support abortion rights. Heading back to the Women's Health Protection Act, the third constitutional provision cited in the finding section, which again acts as kind of a preamble to the bill. Congress has the authority to enact this act to protect abortion services pursuant to its powers under the Necessary and Proper Clause of Section 8 of Article 1 of the Constitution of the United States. So we read that earlier when I was going over Article 1, Section 8. So again, when it comes to the Constitution, the Interstate Commerce Clause, and the Necessary and Proper Clause, some pretty important provisions and pretty consequential when it comes to constitutional interpretation. Okay, so constitutional analysis over. Let's head back into the rest of the findings. Congress has used its authority in the past to protect access to abortion services and healthcare providers' ability to provide abortion services. In the early 1990s, protests and blockades at healthcare facilities where abortion services were provided and associated violence increased dramatically and reached crisis level, requiring congressional action. Congress passed the Freedom of Access to Clinic Entrances Act to address that situation and to protect physical access to abortion services. Congressional action is necessary to put an end to harmful restrictions, to federally protect access to abortion services for everyone regardless of where they live, and to protect the ability of health care providers to provide these services in a safe and accessible manner. Purpose. It is the purpose of this Act to permit healthcare providers to provide abortion services without limitations or requirements that single out the provision of abortion services for restrictions that are more burdensome than those restrictions imposed on medically comparable procedures, do not significantly advance reproductive health or the safety of abortion services, and make abortion services more difficult to access. To promote access to abortion services and women's ability to participate equally in the economic and social life of the United States, and to invoke congressional authority, including the powers of Congress under the Commerce Clause of Section 8 of Article 1 of the Constitution of the United States, its powers under Section 5 of the 14th Amendment of the Constitution of the United States to enforce the provisions of Section 1 of the 14th Amendment, and its powers under the Necessary and Proper Clause of Section 8 of Article 1 of the Constitution of the United States. So once again, the provisions of the Constitution which supporters of the bill say give Congress the authority to enact this act. Section 3. Definitions. In this act, abortion services. The term abortion services means an abortion or any medical or non-medical service related and provided in conjunction with an abortion, whether or not provided at the same time or on the same day as the abortion. Government. The term government includes each branch, department, agency, instrumentality, and official, and other person acting under color of law of the United States or a state. Healthcare provider. The term healthcare provider means any entity or individual, including any physician, certified nurse midwife, nurse practitioner, and physician assistant, that is engaged or seeks to engage in the delivery of healthcare services, including abortion services, and if required by law or regulation to be licensed or certified to engage in the delivery of such services, is so licensed or certified, or would be so licensed or certified but for their past, present, or potential provision of abortion services permitted by Section 4. Medically comparable procedure. The term medically comparable procedures means medical procedures that are similar in terms of health and safety risks to the patient, complexity, or the clinical setting that is indicated. Pregnancy. The term pregnancy refers to the period of the human reproductive process, beginning with the implantation of a fertilized egg. State. The term state includes the District of Columbia, the Commonwealth of Puerto Rico, and each territory in possession of the United States, and any subdivision of any of the foregoing. Viability. The term viability means the point in a pregnancy at which, in the good faith medical judgment of the treating healthcare provider, based on the particular facts of the case before the healthcare provider, there is a reasonable likelihood of sustained fetal survival outside the uterus with or without artificial support. Section 4. Permitted services. General rule. The healthcare provider has a statutory right under this Act to provide abortion services, and may provide abortion services, and that provider's patient has a corresponding right to receive such services, without any of the following limitations or requirements. A requirement that a healthcare provider perform specific tests or medical procedures in connection with the provision of abortion services, unless generally required for the provision of medically comparable procedures. A requirement that the same healthcare provider who provides abortion services also perform specified tests, services, or procedures prior to or subsequent to the abortion. A requirement that a healthcare provider offer or provide the patient seeking abortion services medically inaccurate information in advance of or during abortion services. A limitation on a healthcare provider's ability to prescribe or dispense drugs based on current evidence-based regimens or the provider's good faith medical judgment, rather than a limitation generally applicable to the medical profession. A limitation on a healthcare provider's ability to provide abortion services via telemedicine, other than a limitation generally applicable to the provision of medical services via telemedicine. A requirement or limitation concerning the physical plant, equipment, staffing, or hospital transfer arrangements of facilities where abortion services are provided, or the credentials or hospital privileges or status of personnel at such facilities, that is not imposed on facilities or the personnel of facilities where medically comparable procedures are performed. A requirement that prior to obtaining an abortion, a patient make one or more medically unnecessary in-person visits to the provider of abortion services or to any individual or entity that does not provide abortion services. A prohibition on abortion at any point or points in time prior to fetal viability, including a prohibition or restriction on a particular abortion procedure. A prohibition on abortion after fetal viability, when, in the good faith medical judgment of a treating healthcare provider, continuation of the pregnancy would pose a risk to the pregnant person's life or health. A limitation on a healthcare provider's ability to provide immediate abortion services when that healthcare provider believes, based on the good faith medical judgment of the provider, that delay would pose a risk to the patient's health. A requirement that a patient seeking abortion services at any point or points in time prior to fetal viability disclose the patient's reason or reasons for seeking abortion services, or a limitation on the provision or obtaining of abortion services at any point or points in time prior to fetal viability, based on any actual, perceived, or potential reason or reasons for the patient for obtaining abortion services, regardless of whether the limitation is based on a healthcare provider's degree of actual or constructive knowledge of such reason or reasons. Other limitations or requirements. A healthcare provider has a statutory right to provide abortion services and may provide abortion services, and that provider's patient has a corresponding right to receive such services, without a limitation or requirement that is the same as or similar to one or more of the limitations or requirements described in subsection A, or both expressly, effectively, implicitly, or as implemented singles out the provision of abortion services, healthcare providers who provide abortion services, or facilities in which abortion services are provided, and impedes access to abortion services. Factors for consideration. Factors a court may consider in determining whether a limitation or requirement impedes access to abortion services for purposes of subsection B2B include the following. Whether the limitation or requirement in a provider's good faith medical judgment interferes with the healthcare provider's ability to provide care and render services, or poses a risk to the patient's health or safety. Whether the limitation or requirement is reasonably likely to delay or deter some patients in accessing abortion services. Whether the limitation or requirement is reasonably likely to directly or indirectly increase the cost of providing abortion services, or the cost for obtaining abortion services, including costs associated with travel, childcare, or time off work. Whether the limitation or requirement is reasonably likely to have the effect of necessitating a trip to the offices of a healthcare provider that would not otherwise be required. Whether the limitation or requirement is reasonably likely to result in a decrease in the availability of abortion services in a given state or geographic region. Whether the limitation or requirement imposes penalties that are not imposed on other healthcare providers for comparable conduct or failure to act, or that are more severe than penalties imposed on other healthcare providers for comparable conduct or failure to act. The cumulative impact of the limitation or requirement combined with other new or existing limitations or requirements. Exception. To defend against a claim that a limitation or requirement violates a healthcare provider's or patient's statutory rights under subsection B, a party must establish by clear and convincing evidence that the limitation or requirement significantly advances the safety of abortion services or the health of patients, and the safety of abortion services or the health of patients cannot be advanced by a less restrictive alternative measure or action. Section 5. Applicability and Preemption. In general, except as stated under subsection B, this Act supersedes and applies to the law of the federal government and each state government, and the implementation of such law, whether statutory, common law, or otherwise, and whether adopted before or after the date of enactment of this Act, and neither the federal government nor any state government shall enact or enforce any law, rule, regulation, standard, or other provision having the force and effect of law that conflicts with any provision of this Act, notwithstanding any other provision of federal law, including the Religious Freedom Restoration Act of 1993. So notwithstanding is a legal term of art, essentially saying what comes after the word does not apply. This section is saying that any act of federal law, whether adopted before or after the Women's Health Protection Act was enacted, again, at the federal level or at the state level, the Women's Health Protection Act applies, and specifically, the Religious Freedom Restoration Act does not apply to this bill. And the Religious Freedom Restoration Act is very fascinating in its history and consequences, but I don't have the inclination to get into all of that today. Suffice to say, that would be a very fascinating topic for another time. In a nutshell, if it wasn't exempted from the Religious Freedom Restoration Act, potentially litigants could say the law in some way violates their religious freedom, and that could be a way in which the law could be challenged in court. That is what the Religious Freedom Restoration Act, in effect, has the consequence of doing. In general, federal statutory law adopted after the date of the enactment of this act is subject to this act, unless such law explicitly excludes such application by reference to this act. Going forward, if this bill were to become law, presumptively any future laws would be subject to the Women's Health Protection Act, unless those laws specifically said otherwise. Limitations. The provisions of this act shall not supersede or apply to laws regulating physical access to clinic entrances, insurance or medical assistance coverage of abortion services, the procedure described in Section 1531b1 of Title 18 United States Code, or generally applicable state contract law. Most of that was in reasonably plain English. One section was in very technical legal jargon. That section, or that phrase, Section 1531b1 of Title 18, that refers to a specific abortion procedure, sometimes known as dilation and extraction, that was banned by Congress previously. This bill is saying that it explicitly does not apply to dilation and extraction abortions which were banned in a previous law approved by Congress. Section 6, Effective Date. This act shall take effect immediately upon the date of enactment of this act. This act shall apply immediately to all restrictions on the provision of or access to abortion services, whether the restrictions are enacted or imposed prior to or after the date of enactment of this act, except as otherwise provided in this act. Some laws are delayed in their implementation for various reasons. This one isn't. If it were to become law, it would become law immediately. And again, repeating the idea that laws passed before and after the Women's Health Protection Act would be subject to it and its requirements, with the exception of the specific laws that were exempted in the previous passage. Section 7, Liberal Construction. Liberal construction. In interpreting the provisions of this act, a court shall liberally construe such provisions to effectuate the purposes of the act. Rule of construction. Nothing in this act shall be construed to authorize any government to interfere with a person's ability to terminate a pregnancy, to diminish or in any way negatively affect a person's constitutional right to terminate a pregnancy, or to displace any other remedy for violations of the constitutional right to terminate a pregnancy. So liberal construction is essentially a way of saying, don't interpret this so narrowly as to negate what we're trying to do here. We're trying to prohibit restrictions on abortions. We're not trying to, in a very small way, ban this thing specifically or that thing specifically. We're going out of our way to protect the right to abortion access in a very broad way. And that's essentially an instruction to the courts with regards to congressional intent, with regards to how it would like the courts to interpret this bill that, if it became law, would protect abortion rights. Rule of construction is essentially saying if any crafty legal lawyer tries to come up with a way to say that this bill protecting abortion rights actually interferes with abortion rights, that is not what we're doing. I don't see how that would be likely, but certainly the drafters of this bill are trying to make their purpose and their intent very clear, and I think that they have done so in a rather effective way. Section 8, Enforcement. Attorney General. The Attorney General may commence a civil action for prospective injunctive relief on behalf of the United States against any government official that is charged with implementing or enforcing any limitation or requirement that is challenged as a violation of a statutory right under this Act. The court shall hold unlawful and set aside the limitation or requirement if it is in violation of this Act. This provision is saying that the Attorney General of the United States may sue a government official that violates the Act. In practice, that would mean, under the current political climate, Democratic attorney generals or attorney generals under Democratic presidents would sue to enforce this law very vigilantly, but attorney generals under Republican presidents would not. Private right of action. In general, any individual or entity, including any healthcare provider, aggrieved by an alleged violation of this Act, may commence a civil action for prospective injunctive relief against the government official that is charged with implementing or enforcing the limitation or requirement that is challenged as a violation of a statutory right under this Act. The court shall hold unlawful and set aside the limitation or requirement if it is in violation of this Act. Healthcare provider. A healthcare provider may commence an action for prospective injunctive relief on its own behalf and or on behalf of the provider's patients who are or may be adversely affected by an alleged violation of this Act. So, this section is saying that if you are someone whose right to abortion is challenged by a abortion restriction that was passed into law, or if you're a healthcare provider that provides abortion services, both of those parties, as they're described in legal jargon, would have the right under this bill to sue to prevent those abortion restrictions from taking effect under the law. So even if you had an attorney general who opposed abortion rights, you would still have both abortion providers and women who are seeking abortions would have the ability to sue government officials tasked with enforcing laws at the state or federal level that conflict with this Act, should this Act become law. That was a wordy sentence, but I think I got my point across as clearly as I could. Equitable relief. In any action under this section, the court may award appropriate equitable relief, including temporary, preliminary, or permanent injunctive relief. So injunctive relief is saying the court can rule against a law, and that's something courts often do for various reasons. And so temporary or preliminary injunctive relief refers to stopping a bill as the case is decided in court, which often takes a very long time. Permanent injunctive relief is the idea that generally after a case is decided, permanently the law is prevented from taking effect. Costs. In any action under this section, the court shall award costs of litigation as well as reasonable attorney fees to any prevailing plaintiff. The plaintiff shall not be liable to a defendant for costs in any non-frivolous action under this section. Jurisdiction. The district courts of the United States shall have jurisdiction over proceedings under this Act, and shall exercise the same without regard to whether the party aggrieved shall have exhausted any administrative or other remedies that may be provided for by law. So under some laws, you have the idea that you don't sue first. Try to come to an equitable understanding with, say, a government official. Try arbitration first. Try seeking other ways of resolving the dispute prior to bringing a lawsuit. And there might be any number of reasons why under certain laws you might prefer to have other remedies prior to allowing someone to go to court. But this bill is saying you don't have to worry about that. You can go to court right away. Abrogation of state immunity. A state shall not be immune under the 11th Amendment of the Constitution of the United States from an action in federal or state court of competent jurisdiction for a violation of this act. In any action against a state for a violation of the requirements of this act, remedies, including remedies both in law and in equity, are available for such a violation to the same extent as such remedies are available for such a violation in an action against any public or private entity other than a state. 11th Amendment, very confusing in terms of how it's actually implemented. Essentially saying this is kind of a preemptive attempt to say the 11th Amendment does not apply to this law. Now, ultimately, that'd be for the courts to decide, but that might be a question where courts could take congressional intent into account into cases that involve an 11th Amendment challenge to a law. Whether that would ultimately be persuasive to the court would depend upon how exactly they interpret the 11th Amendment, and that has changed over time. But certainly putting a provision into your bill that says, hey, we don't intend for the 11th Amendment to apply, certainly would be a way to help support the constitutionality of the law should such a lawsuit be attempted. Severability. If any provision of this act or the application of such provision to any person, entity, government, or circumstance is to be held unconstitutional, the remainder of this act or the application of such provision to all other persons, entities, governments, or circumstances shall not be affected thereby. So yeah, you see this in a number of policies or laws or legal documents. The idea that, hey, if for whatever reason a court strikes down part of this law or part of this policy, we expect the rest of it to remain intact. Again, this is establishing congressional intent. You could have an argument, as was argued in one of the lawsuits against Obamacare, not successfully, but you had an argument in court that, well, the law is so interconnected that if any one part of it is unconstitutional, well, the whole thing has to fall. And that argument did not end up winning the day, primarily because the Supreme Court ruled that there wasn't even standing to bring the argument into the court in the first place. But nonetheless, this is the bill's attempt to preempt that kind of argument. And again, certainly it doesn't hurt to have a severability provision within your law just in case. That concludes my reading of the Women's Health Protection Act of 2021. Next, I'll provide analysis and commentary on the proposed bill. The Women's Health Protection Act could easily pass the U.S. House, which has a Democratic majority. However, it's difficult to imagine the bill passing the closely divided U.S. Senate. The bill has 48 Senate sponsors, all of whom are either Democrats or independents who caucus with the Democrats. The two Democrats who don't sponsor the bill are Joe Manchin of West Virginia and Bob Casey of Pennsylvania. Two Republicans, Susan Collins of Maine and Lisa Murkowski of Alaska, have supported abortion rights in the past. So it's possible to imagine the bill receiving at least 50 votes, with Vice President Kamala Harris available to break a tie, if necessary, by voting for the bill. But legislation currently requires 60 votes to pass the Senate, and it's impossible to imagine the bill receiving that many votes. So, for it to pass, the Senate would need to vote to eliminate the filibuster and allow legislation to pass by majority vote. That seems unlikely to happen during the current Congress. The bill also wouldn't be eligible for budget reconciliation, which allows bills to bypass the filibuster and pass by majority vote, because the bill's provisions don't primarily concern the federal budget. So the bill isn't likely to become law anytime soon. The bill, as written, would clearly block state laws that seek to limit access to abortion, which are regularly approved in Republican-majority states. Of course, if the bill were to become law, it would immediately become the target of Republican candidates running for Congress who had pledged to repeal it. I support the Women's Health Protection Act. I support a woman's right to obtain an abortion prior to fetal viability, and the bill creates a number of viable mechanisms to protect that right nationwide. But even if it were to become law, the Republican Party would make repealing the law one of its top priorities. Absent a significant shift in public opinion in favor of abortion rights, the right of a woman to obtain an abortion will always be at risk. Next year, the Supreme Court will decide whether to officially overturn Roe v. Wade. The court has already weakened the precedent by allowing the Texas anti-abortion law to take effect. The court's decision places new importance on the debates happening in Congress and state legislatures concerning legislation that would protect or limit abortion rights. With abortion rights at risk in the courts, I support the effort of pro-choice lawmakers to protect abortion rights through federal legislation. But even if they succeed, it won't be the final word on the endless debate around abortion in the U.S. That concludes this episode of Primary Sources. Join me next time as we continue to examine the primary sources behind today's biggest stories.